This meeting is being recorded.
Okay. Sorry. Yes. I hereby call to order the Board of Fence Viewer meetings at November 9th, 2022. It is now 10:01 a.m. For your information, this meeting is being audio and video recorded. We also have Zoom access. Do we have information to call out? The Zoom. Future reference, we should. This meeting is a hybrid meeting being conducted on Zoom as well. I mentioned this is being audio and video recorded for future publication. At this point, I'd like to ask that we all please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So in attendance, we have myself, William Moore, Miss Nancy Goulart, also Stephanie Schechter. Mr. McKeon is present via Zoom, and Mrs. Kane is here in person. We're talking about the status of 2298 and 2308 Pleasant Street. Would you like me to summarize what I believe? I'm going to summarize what I think is happening and then get input from the two of you. My understanding the last we left off, we all agreed to moving the corner to the correct, we'll call it the correct location as per the deed. Was a document drawn up by Mr. McKeon that we were going to sign to agree to move the marker. And that document then went to the Kane family, which I understand there's some question as to how many people are going to sign it. Now, forgive me, I've been out on vacation. I just got in last night and I don't know what's transpired the last few days, but my understanding was there was supposed to be some sort of documentation coming from Mrs. Kane as to a majority of people can sign it from the trust or not. So at this point, I think maybe hearing from Mrs. Kane is the best.
I did not bring that document as well, but I'm sure it was forwarded over to Mr. McKeon.
Yeah, I don't have that here.
Yeah.
I think it was on my.
So that I heard something about it wasn't from your lawyer. It was.
No, just
Generic law.
yes.
Just statement of this is the law saying that a majority of the trustees. So I guess then the question goes to you, Mr. McKeon. Are you satisfied with getting 3 signatures on that document?
No.
Okay, so in that case, Nancy, I don't know if I'll step down and make a motion, I guess, that we are not going to issue an order to, I don't know if that's a motion or not, but we're not going to tell them to move the marker.
I'm not going to second it, but that doesn't mean it can't come up again. You know what? I will second it for the purpose of discussion. Okay. If the document requires 4 signatures from the Kane Family Trust.
5, I believe.
5 with the.
5 with the trustee, yes. And 1 or more members doesn't sign it. I don't believe we can execute it, which is basically what you're
That's what
talking
I'm saying,
about.
yes.
And I would stop the motion right there. And the reason I say that is because if the Board of Fence Viewers, if the order, do it, okay?
Mhm.
And either parties to the agreement says not going to do it. In order to enforce it, the town would have to take legal action. we do not have a legal
So
budget.
my motion was to not, and that's why I said I didn't know if it was proper or not. I'm saying we are not going to give an order to move the corner because we do not have agreement between the parties.
Okay, but I want you to understand the rest of it, because I have talked to Mr. Hull and Mr. Mullen. Other than this board saying they are not going to issue an order under the powers we have. Anything beyond that, relative, if in fact enforcement is considered, it's got to go back to the town through the Board of Selectmen. All right, because it would indicate enforcement of our duties with legal action. And since we don't have a legal budget, the rules are, it would have to go to the board
To the Board of
for the legal part of it. So would you just read the motion just so that,
I think I'll just
Yes.
all right, I'll withdraw the second.
withdraw the motion,
withdraw?
because it was a really bad motion to begin with. I was just trying to make the conversation that we're not going to order the corner to be moved. Because we've talked about this at length. Because I can't, if you two are not in agreement,
Well, I'm in agreement to move it. I just don't understand.
you're not in agreement because you personally.
Yes,
But the rest of your family is not.
Or one person isn't.
correct. So we can eliminate that one person and just sign the agreement,
What does eliminate mean?
meaning have
one
4
person,
signatures
yeah.
instead of 5.
If 5 are required and one of them is,
But why, how do we? How does he know?
I would think,
Well,
If it were me,
Paper with.
if it were me, I would be talking to an attorney, preferably the one who drew the trust, and say, this is the situation. The majority of the members of the trust are in agreement to take this action with our neighbor, Mr. McKeon. One member of the trust is saying no. So your attorney or whoever
Yes.
can advise you. I would also ask, is it possible to remove one member from the trust?
That was going to be my next move, yes.
And that's, again, you can change
I can.
people in the trust. That would be another option. If that, so assuming we are going to vote not to order the wall moved or anything else at this point, if you look into that and get an opinion from an attorney and take the action, whatever your attorney recommends, then come back to us.
So if I mean, sorry to interrupt you, but right now I'm simply talking about moving the corner. I'm not
Right.
talking about moving the wall. We're just talking about
Right.
moving the
Right.
corner marker. That's
Right.
it. But other than that, I agree with
Yeah.
everything Nancy said,
Well, that was my next move.
but you need to do something
Correct.
to come to be able to move the corner. Okay,
So would it be appropriate for me to make a motion to postpone action on this item until she has an opportunity to speak to an attorney?
Can McKeon weigh in on any of this, please?
one moment, please, sir. I am not gonna second that, okay?
Oh, I'm not making a motion. I'm just saying, is it appropriate? That's all. That wasn't a real.
I would say no, because I still want to have more to talk about.
Okay.
Certainly you'd like to talk, Mr. McCann, please go right ahead.
Thank you, Mr. Chairman. Several things. One is, we have never been provided with a copy of the Kane Family Trust. And I do not know what the actual ownership interests are of the 4 beneficiaries of that trust, which are Mr. and Mrs. Kane and Mr. and Mrs. Tibbetts. Number 2, the document that Mrs. Kane provided only to the Fence Viewers Committee is just a photocopy of generic trust law that may or may not apply to the Kane Family Trust. It's fairly irrelevant information unless you actually have a copy of the Kane Family Trust. Next, if Mr. Tibbetts is unwilling to sign, it's not clear that the others are allowed to remove his rights within or for the property without his assent or approval. So again, without a copy of that trust, nobody can determine what can be done. This is a trust that was brand new. It's executed last March. Everybody should be fairly fresh in their minds about what the terms of the trust are and have a copy of it pretty handy for everybody to view. Next, Mr. Moore, I'd like to comment about some remarks that were made by you and also a result of consultation with Mr. Hull. The fence viewers do actually have the power to make an order, which is in fact a legally binding order, rather than defer back to the selectmen for legal action. If you look at the statute, the fence viewer statute, you are supposed to, when there is a dispute as to the location or condition of a fence, or a stone wall is a fence within the definition of that statute, go out, take a look at all the documentations, see where it should be, and make an order. That is what your duty is, to do this, and that's what I have asked you to do initially and throughout the course of this proceeding. I am very grateful that you extended to the two property owners the opportunity to try to work it out. I spent quite a bit of time drafting an agreement, which seems to put everything on par with everything. Because one of the four Kane family members won't sign it, then there isn't an agreement. All four of them have to sign. What I would respectfully ask the committee to do is to consider the wording of the agreement that I circulated and make that a part of an order for you to enter. Now, it seems to me that if you take a look at the agreement that I sent around, and Mr. Moore and Ms. Goulart, do you have a copy of that in front of you?
Yes.
Okay, thank you. If you would kindly take a look at the drawing that I attached, which is the very last page. It's a drawing, a hand drawing dated October 4, 2022.
Hold on one
And-
second, please. Hold 1
It's
second.
the very back,
Yeah, I must not have.
Oh, can I see that one?
sure.
Okay, go ahead.
All right, did you see that drawing there?
Yes.
It seems that I need to further explain some of the notations on that. And then once I explain that, I think we actually do have agreement as to where the drill hole shall be. You'll see the square there. That is that yellow shed that's on my
Yep.
property. Okay. And if you will see, there is a 7-foot designation with an arrow pointing to a line.
Yep.
You see? Okay, so if you went from the corner of that shed and you went 7 feet to the stone wall, that goes to where the drill hole should be. And on the other corner of the shed, you'll see an arrow with a numeric designation, 6 feet, 10.5 inches. Okay, so if you go from that corner of the shed to the stone wall, that goes to exactly where the drill hole should be. So those two measurements, if you will, are triangulating off of the yellow shed. And then you'll see the third numeric designation, which is 78.2 feet. And that is the distance from the medallion to where the drill hole should be. All right. Now, I believe that all parties have agreed with the location of the Kane's green fiberglass snow poles, and the two orange snow poles that I put is that the drill hole should be exactly where I have shown on this drawing. Okay, everybody has agreed to that because they moved the yellow stakes, I'm sorry, the green stakes, to be on a straight line to where that hole should be. And frankly, it's only moving the drill hole 6 inches. I mean, it's a very small amount. It's just that the bulge, which is in the vicinity of the shed, actually goes further than the drill hole. So number one, everybody agrees where the drill hole is. Number two, by statute, you do have the authority to order the drill hole rock to be moved back to where it should be. And number three, by statute, you have the authority to have that bulging line ordered to be restored to the, if you will, the straight line from the drill hole all the way out to Pleasant Street. I have requested throughout this that, you know, any delays on this should be very short, that if there are going to be continuances from one meeting to the next, that there be very certain and specific orders from your board about what should be done during that interim period. We've had a 1-month time period since the submission of the drawing and my proposed agreement, which was on October 10th. Really, nothing's happened in the interim. So what I would ask is this: if the Kane collective family, after consultation with council, will not sign the agreement as is, or alternatively remove the holdout from having any legal interest in the Kane property, with the remaining Kane family members, including the trustee, agreeing to sign, I think at the next meeting, I would ask the fence viewer committee to make an order in conformance with the agreement that I had. I'm open for any questions. Thanks for giving me the floor and the time to express myself, and I turn it back to you.
Thank you. I agree with most of what you said. The one part I would take exception to is that, no, I do not believe we have any authority to move property markers. It's very clear in the statute that we are to decide where the wall is. And I honestly am ready to make a motion on that right now. But as far as where the marker is, I cannot issue an order to say to move the marker. That's in the purview of the land court and a surveyor. And also you mentioned that everyone is in agreement. That's not true. Mr. Tibbetts is not in agreement and he's part of the trust. So most of us are in agreement, but not Mr. Tibbetts. And that's going to make a problem for moving of this corner.
Yeah. If I may, go ahead.
I do believe that we're pretty much all in agreement about where this wall should be. And I think it would be appropriate at this time. I would entertain a motion to move the wall to the place that we have all agreed upon, but not move the corner. I think that would be the correct.
I don't think it solves the problem. I think the most important thing is the drill hole, then the stone wall can be repaired. But
So going back in time, initially, the problem was just moving the bulge. And it was afterwards, it came to our attention that the drill hole had to be moved as well. The bulge is much further out. I mean, as Mr. McKeon had said, that the drill hole is only a little bit off by some inches, whereas the wall's over by feet. So moving the wall, we can move the wall to the place that we've agreed that the drill hole should be.
Mhm.
We can order that. I'm just saying, I am not willing to say, move that drill hole without everybody agreeing. But we can move the wall. That is our purview. If you look at the definition of a fence viewer, it clearly says we have the right to tell people to move the wall here and then go to court and figure out the problems later.
Okay.
We're not-
And if
we're
I
not-
may, Mr. Moore, if I
Sure.
may, I would like to, following the close of this meeting, to forward to you the authority in the statute that says you get to decide where the fence goes. And if that includes.
That's exactly what I just said, was we decide where the fence goes,
Right.
but we do not
and
decide the line. I've said that several times in these meetings. We do not decide property lines.
That's where I'm going to respectfully offer to supply to you the documentation that does absolutely empower you to do that. That is the quintessential role of the fence viewer, is to decide what the line of the fence should be. And that line of the fence should go to where the drill hole should be. And I'll be happy to give you that documentation at the close. I just
And
don't have.
I'm agreeing with you. I'm agreeing with you. That's what I'm saying, is that I think we should move the wall to where we think it should be and call it a day. If you guys want to fight over where to move that property marker, that has to, I think you need to correct the document and you need to agree to it, or you need to go to court and fight it out. But I'm not going to order that the corner be moved without complete agreement.
Well, this is a package deal, I think. If you move the stones, then isn't the drill hole still going to be to the, if I'm
6
looking
inches
east,
to the, yeah,
if I'm looking east, it's 6 inches south of where it should be.
Correct.
correct.
Well, doesn't resolve the whole problem. I understand what statutorily we can do. And yes, we can order thus and so. That's fine to order it. How do you enforce it? To enforce it, if the parties say one
I don't
party,
do it. I don't think there's any issue with enforcement here. They're both agreeing to do it.
If I may, I believe it was 2 meetings ago, Mr. Moore, that your board actually did enter an order for the Canes to actually do the 78.2 inch measurement. Take a look at your minutes, please. And
Yes, yes,
it will reflect that you have already ordered them to do the measurement and to replace the stakes where they think the drill hole should go. And they have, and everybody's in agreement that it should be in the place which is reflected on my drawing that shows the triangulation. So you've made an order, there's been compliance with it, and you should just simply incorporate that into your final order.
but everyone's not in agreement.
But you've already made the order, which was, and that order does absolutely bind Mr. Tibbetts.
Well,
Not if he has to sign a document, it doesn't.
No, no, no.
I want to get, no,
In
I'm
advance-
talking,
Sorry,
all right. Let's try this. So we issue an order to enforce the 78.2 feet and that the wall gets built.
just that the wall
Gets
move.
built.
The corner does not
Okay.
move. I think that's important,
Well,
really important.
no.
no, wait a minute. This is my scenario.
Okay.
I don't agree with that. The order would be, since we've already agreed to 78.2 feet and it has been measured, and we were up to the point of getting signatures. Right now, we got a problem because we can't get all the signatures, but if we issue the order to put the stones back on top of, I'll say on top of the base stones, okay? Now, is this where the mason comes in? Because there hasn't been agreement on the mason. I mean, we got quotes and the two, Mrs. Kane and Mr. McKeon said they would, split the difference, split it in half. Excuse me. But that mason is going to be looking for that drill hole. How do you tell them rebuild this wall, but you're not doing it 78.2 feet to that corner? That the drill hole is still going to be in the wrong place. According to the 78.2 feet, which we know is in the deeds. So that's my concern. Fix the stone wall, put the stones that are south of the existing base stones. Rebuild that wall so that those stones are sitting on the base stones. A mason is going to say, wait a minute, the drill hole, the cornerstone is 6 inches beyond where I'm supposed to be. I mean, that's the problem I see.
It's an interesting thought. I don't know if masons pay attention to property lines that much.
God, I would hope so. So we can get it resolved once and for all if we're going to do it.
No, I do agree that by doing one and not the other sort of does leave things a little bit in limbo. But I'm trying to say, what is the extent of our authority as this board? So I think, I suppose we have what, three options going forward? Yeah, we have three options. We can either do nothing. Just, we're not gonna order anything. Two, we can order the wall to be moved and leave the drill hole where it is. Or three, move the drill hole and wall.
No, fourth option is to have Mrs. Kane contact the attorney who drew the
Yeah, that's to
trust
do nothing.
documents.
Let's do nothing.
No, no, and what my point was postpone the decision or move it to the next meeting. And that is key. What she finds out is going to be key to whether we can say, okay, we got an agreement, it can be done. Or, okay, that fifth signature is needed and it's not going to happen. Therefore, the only thing the town is looking at is going back to the three options you're looking at.
Okay, so I might be willing to do that, but just for the sake of discussion, what if it doesn't happen by our next meeting? What if she comes back and says, I still can't, get anything, we have to do something. So will we say that at our next meeting?
No, I don't agree with that. The meeting will be in 3 weeks if we have a quorum. Obviously, you got to get in touch with an attorney and hopefully have that person review it and give you something. Preferably, especially if he says you don't need the fourth signature, we got to have it in writing because then that even bolsters our position more. That's the enforcement if the attorney says that. But it's not like either property's for sale and the boundaries got to be straightened out and do all that other stuff. I think the option of the interpretation of the attorney who drew the trust, I don't need to see the trust. All I need to hear from an attorney, hopefully the one that drew it, what does this mean? You can explain to him the problem we're trying to resolve. And we also have the other property owner that's saying, yeah, I agree as far as where it should go.
It can't be just her attorney, though. I agree with Mr. McKeon that he needs to see either the document or he needs to talk to her attorney and have some sort of, understanding. We can't just take her attorney's word. Oh, yeah, it's okay. He needs to have his attorney.
No, it would be in writing.
Yeah.
It would be in writing. And certainly, if I were in her position, I would do exactly what I said. Get in touch with the trust attorney. Say, this is the problem I got. Get it.
Yeah.
And give me your decision in writing. Because once that decision is given, that along with any other documentation we're talking about would go to Mr. McKeon for review to see if he agrees. All right.
But I think as part of that, is there any issue with providing Mr. McKeon with a copy of the trust document?
No.
I mean, I think that should be. The thing is that he or his attorney should be able to come independently to that same conclusion.
That's my point.
Right. So in order to do that, he has to have access to the document, which I would think be filed somewhere, but.
Yeah, they get recorded. They get
yeah, so-
recorded.
Please provide him with a copy of the trust document. Certainly to go forward. So you want to move to, I will entertain a motion to postpone this to the next. Well, before that, Mr. McKean, do you have any further input before we postpone this?
Thank you. I would like to bring finality to this and I would like to get that wall fixed, which I had offered to do by myself at my own cost over the summer. And, no good deed goes unpunished. Number two, I do not know why you are reluctant to enter an order about the location of the drill hole, because you already did make an order on September 12th. And I'm looking at the minutes now on my phone. And it was, let's see, it was voted unanimously on Mrs. Goulart's motion to have the Kane family measure the boundary from the land court medallion at the intersection of the Carton Kane McKeon property south by 78.2 feet to determine the location of the drill hole in the stone wall and report to Stephanie Schechter by September 19th. your order has already been made. It's already been complied with. Where the canes measured, where they located, where the drill hole should be, I am in agreement with. All right, and I think your order applies to all 4 or 5 of the possible cane people. My issue with the trust is, I don't know if the trustee has the authority to act on behalf of the individual beneficiaries, or whether or not beneficiaries also have to sign off. Finally, I would be very grateful if you would re-emphasize that any written submissions to your commission should also be to all of the parties, as I have done. All right, I haven't gotten copies of the Kane submissions from the Canes. They've sent it to you. I find out later on, and then your commission has to send me
What did they
copies.
submit?
So hold on one second.
Oh, the trust documents and emails.
Hold on, so we have not received a copy of the trust document.
We only
Anything
have
we-
that generic one that I sent to you because she brought it into the office. It wasn't an email.
And
Right,
as
that-
we've said before,
that doesn't help.
anything that comes from either one of you will go to Ms. Schechter and she will forward it to the other person, which she has
I
done.
haven't, have you sent me?
So
anything?
you have
No.
received everything that we have received.
Yes, my clear understanding of your former order was anybody that submits anything to your board will simultaneously provide it to the other party.
Okay.
That's typically what's done.
I'm also hearing, what you're saying is two contradictory things. On one hand, you're saying that we should order that, we have the right to order to move the wall and move the corner, and we should just do it. And at the very beginning of this meeting, I said, are you willing to accept the document, signed by 4 of the 5 people? And you said no. So it's like,
Yeah,
I'm
that's not-
stuck in the middle of which way do we go? I mean, if you accept 4 out of 5 signatures, I'll be more than happy to try to go forward with making a motion right now, making an order right now. But you said you were not comfortable with that, which is why I
Right.
said no.
Right. The agreement is a settlement agreement, which has to be signed by all affected parties. You can't settle with 4 out of 5, because then the 5th person still retains their rights under this proceeding, and you're still stuck with having to make an order. So either we all come to global agreement, or your committee makes a decision.
Okay.
So they can convince Mr. Tibbetts to sign it if he's the holdout. They can remove Mr. Tibbetts, or they can convince everybody that Mr. Tibbetts doesn't have to sign it in order for the trustee to sign on behalf of everybody.
Okay. Mrs. Kane, how do you feel about that? What, do you believe we can go forward with, as Mrs. Goulart said, to find an attorney?
Yes, yes,
get,
yes.
I mean, so you need to provide him with the trust document. That's, send it to him directly. Please send a copy
Yes.
to Ms. Schechter. That's like foundation. That's number one. You've got to send that to people so we can all be on the same page. All right. If your trust document does state that Mr. Tibbetts needs to sign it, then you will research ejecting him from the
Correct.
trust. Okay. And you will report back to this board.
Yep, before 3 weeks, because 3 weeks is.
I prefer if it was like.
It's going to be before, yes,
Week or 2.
yes.
Okay, so we have plenty, everybody has plenty of advance notice. Okay,
Yes,
Nancy, do you have
Yeah,
anything to add?
and that whatever your attorney says is in writing,
yes,
and if you send it to Mrs. Schechter, we'll make sure Mr. McKeon gets a copy, and then he'll get it and be able to look over that attorney's information, recommendations, whatever, compared to whatever's in the trust.
May I further request that this attorney who was making the review be also sent a copy of the proposed settlement agreement that I circulated last month?
Can you send that to him? Just give the attorney the, this,
Yeah.
The contract.
yep.
have him review that.
I can resend it to you.
I have it. I can get it. I have it.
Thank you.
Okay. Anything else?
No.
You all set?
Nope.
Anything else, Mr. McKeon?
No, thank you very kindly.
You good?
Yeah,
All right, so I entertain a motion to postpone.
yeah, just a minute. What is the date of the next meeting? The 8th?
We got Thanksgiving coming, so I have the 30th,
Okay, that sounds about right.
Say the
Because of the
30th?
holiday.
yeah, November 30th. Every
Can you
3
guys, that's
weeks.
my birthday. Can you guys settle this as a birthday present, please?
I can.
Would that be
I don't
10, would that be 10 o'clock?
Probably, right?
Yeah, probably, yeah, because this is the board meeting. So we usually do them together.
Yeah.
Right. Again, I will likely not be physically present, but send a Zoom notice.
We can do the same thing. Yep.
Thank you very much for doing that and accommodating that this morning.
So I make a motion that we postpone further action on
2298 and 2308 Pleasant Street.
to the meeting of November the 30th.
Step down in second. Any discussion? All in favor?
Aye.
Aye. Motion's unanimous. Okay, no new business. Public input? Public have anything to say? Correspondence? Minutes?
Yep.
I did send Mr. McKeon a draft of this, so he would have the minutes from.
Yeah, this was.
Everything. Thank you kindly, and I'm gonna check out of the Zoom meeting. Thank you very much and happy Thanksgiving to you all.
Yep.
Thank
Thank you.
Sure.
Bye-bye.
Nancy always goes over my minutes, so they're not straight up my minutes, because way too much.
They're our minutes.
Yes, they're not.
Yep.
Way too much.
All of it.
This looks good. I'm happy with it.
Good.
I make a motion, what's the date of this? meeting,
9,
Please.
12. November 12th. November, September, sorry.
Oh,
September 12th.
okay. I move that we accept the minutes of September 12th, 2022.
Step down in second. Any discussion? All in favor?
Aye.
Aye. Motion's unanimous. Unanticipated items. Any motion to adjourn?
So moved.
What time?
Motion to adjourn, all in favor? Aye.
Aye.
Yep, 10:41 or 10:42.
This can't be cut and dry, can it?
11:42.
It's still recording.